of Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation? Welcome to Surviving the Survivor. It is the show that brings you the very best guests in all of true crime on trending criminal cases. This, sadly, has been a case that's been in the news since July of 2014. Of course, the death, the murder of Dan Markel in his Tallahassee driveway. 2 hitmen charged, convicted, 1 cut a plea deal. The middle woman spending the rest of her life in prison. Charlie Adelson, the ex-brother-in-law, he is also serving a life sentence, and life in Florida is life. Unless the Latin Kings want to get you, then it's life in South Dakota where he's being hidden, but he is still serving life. Donna Adelson, the matriarch of the family, she is set to go on trial. It was supposed to be June 3rd, which had been just a couple of days, but it's been pushed back to August 19th, and her defense gets her way. They are going to try to push it back even more. So let's get this started here. Best guests, we got Tim Jansen, former federal prosecutor, now the famed Tallahassee criminal defense attorney, R, the letter R, and O-U-R, Timothy Jansen. Next up, Jessica Mishali, Boca Raton-based criminal defense attorney, very savvy in that courtroom, and she will help us break this down from the defense side. And last but not least, another fan. We got some fan favorites on here tonight. Josh Ritter, the man with the silver fox here, our silver fox, former LA prosecutor of the year, current criminal defense attorney, but most importantly, besides being a good husband and father to his children, he is host of Courtroom Confidential. You can find it anywhere you find podcasts, but you can definitely find it on YouTube and check it out. So, Tim Jansen, I'm going to start with you. All of us were talking a bit behind in camera, if you will, but not on camera. And I was basically telling you that a lot of this is essentially Chinese to me. I'm not understanding a lot of it. I get bits and pieces of it. So just very broadly, the defense hired a motion for a rehearing here based on secretly fed false information to Judge Everett. So what is going on right now? And this is Donna's apparently appellate attorney, which I didn't even know existed. So break this down for us, and we'll have Josh and Jessica jump in.
Well, you can have an appellate attorney on prior to trial. They usually assist in making sure issues are persevered and saved for appellate review. The appellate lawyers are experts, so they know issues and they make sure you preserve it. Now, what's in this motion is a third. They want an en banc, which means they want the whole court to handle this hearing instead of a 3-panel judge. And they put some explosive details in here, but there's some things that are in here that are interesting because there's been rumors and have not been confirmed that one of the lawyers for Donna had slipped a phone in to the jail, and while at the jail was allowing Donna to communicate with Harvey. Now, I don't know if it's true. And I'm not saying it's true. And I certainly am not saying that these lawyers are trying to get witnesses to falsify. They deny that. But when you look on page 10, paragraph 28 in the Penn Register, it clearly states that first, the investigator, that would be Jason Newland, went to the judge to get, and they're saying Harvey is apparently relaying information through attorney-client calls, privileged calls. Now, attorney-client calls are privileged. They can't be recorded. Sometimes they are, but they're not supposed to be. And the reason for this in the jail, you can't bring a phone into the jail, the Leon County Jail. That would be considered contraband. So if you bring it into the facility, you're committing a third-degree felony. And then if you let a client use the phone unrecorded, that's a more serious violation because you're seeing this last part, cannot be monitored, as well as potential threats may be orchestrated. That means like escapes or threatening people or trying to harm. But if you look on page 11, then you see they talk about they got a pen register and trap and trace, and that's just basically seeing who's calling, what number is calling, when, and where. But they're saying in there that in the affidavit that there were, during attorney visits, there are overlapping communication records between Harvey Adelson, the defense attorney's cell phone, and attorney visits. So what this says in this affidavit is that they believe that the lawyers were in the jail visiting Donna, and there were phone calls from that lawyer's phone to Harvey, which should not be happening. Now,
Tim,
serious allegation, if true, and I'm not saying it's true, but this is gleaned by looking at the motion for a rehearing.
Yeah. So, Tim, just clarify, because again, this I have to be very open about, that I am not clear on.
Okay.
Got the motion late in the day, but my question to you is: this allegation is being made by the prosecution against the defense, and now the defense is raising this in this motion. Is that how I understand? Is that correct?
That's true. They're fighting for a different issue. They believe that the judge should be recused because he got information during these ex parte requests for pen and trace, and then used that information in one of the hearings, which I think there was a part in there where the judge did say, I see you've had plenty of time with your lawyers, and they correctly note there was no evidence in the record how much time. So there is some merit to some of the arguments. But I highlighted this because what I had been hearing, and now it looks like it's confirmed, that at least there might have been some phone calls being made with Donna to Harvey with the attorneys. Now, I'm not saying it's true, but I'm saying this is what the defense put in their motion in response for a hearing, claiming this was in the affidavit that's still under seal.
Yeah. So, Tim, obviously, Tim has been in Tallahassee for about 40 years. So it's not that big a city. So, I mean, Tim, there was, you had actually sort of filled me in on some of this, but this is all kind of going around the rumor mill. So again, just to add on to what you're saying, that's kind of been the word on the street, but not necessarily. And you're saying that this motion is perhaps underscoring that, even though it is a defense motion, but sort of incidentally underscoring this.
Well, it at least confirms there are overlapping communication records between Harvey Adelson and the defense lawyers while they were visiting Donna. That's in this document.
Yeah. So, and this is that part of page 11 that Tim was talking about. And then there was a previous page that the COE had up. But Jessica Mashali, I guess your reaction to hearing what Tim just laid out, because if true, it's a very serious allegation. I mean, and we're certainly not saying that we have definitive proof or even any proof of this, but this is again coming up incidentally in this motion. But I mean, how serious or not serious an issue is it if a lawyer potentially is bringing a phone in to a jail and allowing their client to make calls on that sort of in a private manner?
It's extremely serious. It's a crime. Any lawyer who would do that would be arrested. If there was proof, they'd be convicted. They would never be a lawyer again. It's an extremely serious allegation. It's a story for another time, but it's something I've been accused of myself. And of course, it was not true, but of course, it was extremely salacious and, really a big deal. Other lawyers have been disbarred for the same that I'm aware of, that I've seen. It's extremely serious. What's happening here is the defense is saying that because this judge saw this, and I think the defense is 100% right. And if I was the defense attorney, I would be fighting like hell for this. This judge saw a serious accusation from the state that these lawyers are committing crimes in favor of their client, right? that it is going to the level where they're helping their client use a phone, which, by the way, when you use a phone from jail, like Tim said, that's how escapes happen. I mean, you could arrange the murder of somebody, right? People have gotten phones in jails and used that phone to arrange hits on other people. This is extremely serious. For them to be involved in that and for the judge presiding over the case to know that, right? And to see that in a legal document, he is going to give it validity, and he is not going to be fair to her and her team because he doesn't respect her lawyers any longer, right? So the reason that it's in here is not because they're admitting that it's true. They have to put it in here to properly defend their client and say, hey, wait a second, this judge saw this. This judge does not belong on this case anymore. And I think it's pretty clear they're right.
Yeah, this is it just got interesting real fast with Tim laying it out and Jessica hopping on there. Josh, before we dig into this a little bit more, I assume from what I'm hearing that they don't take lawyers' cell phones when you go to jail. Is that right, Tim? They when you go into the jail, they allow you to keep your cell phone?
No.
I will tell you, most jails do not let you bring them in.
Okay.
Leon County, they get lax with lawyers and bar cards. There's a sign. It used to be we could bring them in, but then a lawyer was doing the same thing. A lawyer would go in there and let their clients talk on phones non-recorded. So now they make it so no lawyer can bring a phone in. And there's signs you can't bring a phone into the jail. Now, I'm not saying it's true. I'm not going to discredit any lawyer. I'm just saying based on what these motions say.
This is fascinating. Josh, I just want to give you a chance to weigh in here before I kind of dissect it down to a more base level.
Yeah, I wish I had something more interesting to add, but I mean, Tim, really does a great job of reading through kind of the in between the lines of what is being said here. I will point out, just in fairness, what the defense is saying in those highlighted portions that we showed is that they're saying these are false allegations being made. That this is the information that was provided to the judge in the affidavit seeking warrants, but this is false information. And furthermore, it made the request for ex parte communication invalid because we should have had an opportunity to reply and respond to these false allegations before the judge made any kind of ruling on this. It's interesting because this motion is asking for reconsideration of a motion already denied by Judge Everett. In Florida, I'm no Florida expert. My understanding, though, is that initially the motion to have the judge recused or removed goes first to that judge, and that judge makes an initial inquiry based upon just the legal basis, assuming all facts to be true, just the legal basis. That Everett denied those motions. Apparently there were two based purely on the law. They then appealed that up. That appeal was denied, and now they're asking for review of the denial of that appeal, and they're asking for it to be done en banc, meaning the entire court takes a look at it because they feel like these issues are so fundamentally important. But what they're saying is not the reasons. They're agreeing with the court that yes, a judge is allowed to look at warrants, and a judge is allowed to look at warrants concerning cases in front of him. But they're taking issue with the timing of this, which I'm not as sure as to that argument as much as the other part being this is not what's contemplated when we're talking about a judge going ex parte, is not certainly having this kind of information that is so accusatory of the defense without allowing the defense to have an opportunity to respond. So it's a little bit of a in the weeds sort of an argument, but I think the biggest takeaway is what Tim has already pointed out, is that I think the reason they're most offended by this is it's true. What is being alleged is without flat out saying it, it is the only way that you can arrive at the conclusions made in the affidavit are if the attorneys are committing criminal acts.
This is both crazy and convoluted, at least for me. I don't know if I'm the only one, but
convoluted for sure.
Yeah. So Tim Jansen, let me ask you this. this is all the way I see it. It's almost like calling a bluff in poker now. So now the defense is saying this didn't happen. They're accusing us of this. So now if the state has any sort of tangible proof of this, wouldn't they have to come forward and say, hey, this is what we have, Judge?
Well, if you look at what the defense is denying, they were denying the right to impeach a confidential informant, which might have been one that they said has numerous felony convictions. If you look on page 6, that they could impeach him, and they didn't get an opportunity, which is correct. They didn't. That doesn't say anything about there was no phone calls, right? Now, it looks to me like they're denying that they would never be tampering with witnesses, which I'm sure, and I hope they are, and I'm sure they're not doing that. And there are some points in there that are valid, that the timing of this motion for these trap and trace and these allegations of misconduct by the lawyers before the judge who's handling hearings, including motions for bond, that is kind of problematic. Because if you throw something up there that the lawyer is being unprofessional and possibly maybe committing a crime, and this same judge is ruling on your hearings, and you never got a chance to respond to these bombshell allegations in these affidavits, it does kind of give an unfair advantage to the state. And it affects their reputations. And judges rely on reputations a lot when they decide motions in court and how their rulings are. If they get a lawyer they know they can't trust, they're not going to side with them. And lawyers and judges do know lawyers who do not always give them the truth, sometimes skew things that the judge doesn't want to get overturned later on. So this is, I say this is a pretty good motion to recuse the judge, but I find some of the allegations in there really concerning if they're true. Like, I don't know if they're true.
Yeah, this is pretty wild. What
Can I
yeah,
I'm
hop
so
in,
sorry
Judge.
I'm just wanted to, this is the part I'm not, and maybe I'm missing something. On page 11, as you pointed out, Tim, there's this portion that's in bold.
Yep.
And this is the they're taking this from the affidavit for the application for the pen register and trap and trace.
That's under seal, still under seal.
To try to get that against Harvey, right? How then do they know at the time of writing this affidavit that Harvey is communicating with the attorneys?
You're looking at the bolded part here is what Josh is referring to.
Yeah, they're saying there are overlapping communication records between Harvey Adelson, the defense attorney's cell phone, and attorney visits. So how do they know that Harvey is communicating with the defense attorney's cell phone if they don't have a trap and trace in place already or pen register in place already? Do you see what I'm saying? Am I missing something?
I think they started with the records. Their first affidavit, their first warrant was for the records.
Gotcha.
And then they did the trap and trace.
So they've got records that they can line up with attorney visits.
That's right.
Gotcha.
So there were two of them. One was on April 7th and another one was later on.
Again, I'm still wrapping my head around this, and this doesn't sound like it's too good of foreshadowing here. In other words, this could get upended again, is what I'm thinking. It's supposed to start August 19th, and who knows at this point. But Jessica, let me ask you this. Let's go inside Judge Everett's home for a minute, metaphorically speaking. He's sitting at his kitchen table. What is going on in his mind when he sees this motion here to basically kick him out and recuse him from his case?
I mean, I said it before and I agree with Tim, and I'll say it again. He should be recused. I mean, from a criminal defense attorney, this is so outrageous what's going on here. So I know everybody's trying to wrap their head around this and look at these accusations, but this is not about whether the defense attorney has committed crimes. I know that's the more sexy aspect of this, but this is not about that. This is about the defendant's rights. The defendant should never be in a situation where the judge knows more about her case than her lawyers do, right? The state took serious matters that are very, very sexy and interesting to the world, to this judge, and brought it to the judge without her or her lawyers ever knowing about it, right? In an ex parte communication to try to get a warrant. Now, ex parte communications are allowed in such narrow circumstances and only when they're absolutely necessary. But they do often lead to judges recusing themselves voluntarily, because once a judge finds something out ex parte, that judge should know for themselves. I feel the judge should have recused himself without ever getting a motion.
Yeah, and Jessica, just define for those of us who are non-attorneys, what does ex parte mean in layman's terms?
It's a communication between the judge and one party, right? So the ultimate job of the judge is to not take one side over the other, right? The judge has to be neutral. That's the entire role. The judge must be neutral. Now, when a judge has an ex parte communication, again, they are allowed, but in very, very rare circumstances when they're necessary. Here in a case like this, where Donna Adelson being accused of murder, right? It's that serious. And when there's been as much drama as there's been for 10 years, and the judge now is reading something that says her lawyers are committing crimes, sneaking a phone into a jail, allowing her to use it and allowing her to make calls where she witnessed it, where she tampers with witnesses, right? And any one of those things alone are serious enough. For the judge to be given that information, that's enough for him to recuse himself. That's enough. She doesn't know that. Her lawyers don't know that. There's no opportunity for them to defend it in any way because they don't know about it. And it's very hard for me to believe that any human being, I'm not saying there's anything wrong with this judge. I feel any human being is sort of changed by everything they hear. You can't unring a bell, right?
Yeah.
We say that in court all the time. You cannot unring a bell. And this bell has rung in his ear. And what I think he's sitting at home and thinking is, oh my God, I can't believe these lawyers did this. Oh my gosh, right? It's so exciting.
I mean, is he angry? Do you get upset about this? Because they're basically, I mean, to a degree, kind of calling him out, right? That he had this privilege and information, I guess, which I guess was not really in his control. He was getting it from the state, but is this something that would anger him, I guess, is my question.
Well, they're calling him out to the Court of Appeals, right? Because like Josh was saying before, it first goes to the presiding judge to make the decision himself. I mean, first of all, he could have recused himself without ever receiving a motion. If a judge is ever in a position where they feel that they should recuse themselves, they go ahead and do it. They don't need a motion. So that's one. Then step two was he received a motion. And the motion let him know, we think you need to recuse yourself for these reasons, and laid it out to him. And he decided, no, I'm not going to. In the business, I don't know if these guys will agree with me, but we usually say, like, if you file a motion and there's grounds, the judge really, the best thing for them to do is just recuse themselves so that it doesn't go to a court of appeals. If they recuse themselves, they've done nothing wrong. That doesn't mean they've done they're not admitting to wrongdoing. And in fact, it's not his fault. They submitted a motion to him. Right? It's the state's fault. It's the state's fault for what they did. So he's done nothing wrong, and he could have just walked away, right? He could have just walked away from the case, but he didn't. So they are calling him out to the Court of Appeals and saying he didn't do the right thing. He doesn't belong on this case anymore.
Yeah. Roxanne A here. I seriously think this trial is going to get delayed again. Be prepared, people. It sounds like that could definitely be the case. And then from Gretchen here and STS, please jump in with questions, because I'm as confused as many of you, but you're probably less confused than me. It seems unfair to say that Judge Everett no longer respects Donna's attorneys. He hears all kinds of negative info and is trained not to prejudge, but you just heard Jessica say, once you ring a bell or take the toothpaste out of the tube, you can't put it back in. You can't unring the bell. Josh, I'm just hung up on this. So you're the former LA prosecutor of the year and host of so let me ask you this. LA prosecutor.
Butter him up before you knock him down.
Congratulations.
Yeah. No, my question is, I mean, if you're Georgia Cappleman and you're making these accusations, and this is what I asked him, I mean, don't you have to come forward now with some sort of tangible evidence to say, hey, this is how we know this? That would obviously, be a real serious issue that's potentially criminally incriminating. But what do you do? I mean,
Well, for the purposes of this motion, though, I don't think, as Jessica pointed out, that's really not the issue. Whether or not there's any validity, they're saying it's false, and they want that to be known that it is false. But it isn't so much the fact that the truth or falseness of the accusations as much as it's the judge never should have heard these things in the first place. And if the judge was going to hear these things, he should have shut down the ex parte. Their argument being he should have shut down the ex parte and should have allowed for an actual hearing so that they could dispute these allegations if he was going to grant any kind of a warrant based upon these allegations. That's their argument. So it doesn't really go towards their it doesn't really matter for their purposes of the recusal of the judge whether or not there's truth to it. But a thing that I don't know, and maybe somebody else on the panel knows, it would be interesting to me as far as whether or not the court is going to do anything about this is I can't imagine they did not have these affidavits as part of the original appeal that went to the court and was denied. So if in that appeal was these affidavits with these statements, these allegations about the defense attorneys, you would imagine, maybe everybody will disagree with me, but you would imagine that the Court of Appeal will say, yeah, we've already heard this. We've already seen these allegations. We already know that the judge considered that, and we still stand by our reason that this is essentially routine judicial review of warrants, and judges are allowed to review warrants, and warrants include allegations in their affidavits, and nothing here is outside of the norm, and we're not going to, what do you call it, topple the turnip cart or whatever it is in order to allow this judge to be recused just because he happened to review an affidavit. I don't, if in other words, to me, this might have more success, and maybe I'm being cynical, if they're telling the appellate court something they didn't already know the first time around. But I have a feeling that if they already knew this the first time around, whether or not it's that same panel or the entire panel is going to go, we've heard this, nothing's changed our minds.
By the way, before I forget, Phil and Scott are back tomorrow, new time, 5 p.m. because Phil, the real life Magnum PI, is back in Hawaii. Annie K here. Tim, what would Donna's motivation be here to delay indefinitely, which I don't understand because I think she hates jail more than anybody and she wants to get out. But is there any sort of ulterior motive, I guess, with this?
Well, I don't think on behalf of Donna, other than getting a fair trial with a fair judge. The better course of action in this case would have been to take this to a separate judge not handling this trial. Now, the other issue we got is Judge Everett is the criminal administrative judge for the circuit. So when you don't have a case, he's the supervisor. When you have questions, complications. And on the other hand, should they have given the defense an opportunity to respond? You would think yes. But what about this? You got people allegedly, possibly committing crimes. The courts don't put on notice and tell defendants that I'm signing this warrant because you guys are in the middle of a criminal activity. So he's caught in the middle. And I think that the prosecution, the investigator, should have taken it to a separate judge to review the warrant. I mean, that could have been done. I'm sure that Everett is not happy about this. I'm sure it's one of those things as a lawyer, sometimes it comes across you like, oh man, I didn't want to know that information. Now I got to call the ethics hotline to see what I've got to do because it puts me right in the middle of my client. And no one likes it. No one wants it. I don't know, Josh, if they told the appellate court these issues. I think I would have caught that in the first round. I don't remember any of the affidavit being leaked because it's still sealed. And this is the first time that anybody has seen these kind of allegations. Even when they had the hearings, the first thing the judge said, he said to Sarah, are there any charges pending? Are you going to supersede it? And she said no. But I don't think that's enough of the inquiry to determine whether he's got a conflict. And if you're in doubt whether or not you should recuse yourself, the better cause of action is to recuse yourself because the defendant's right to a fair trial is paramount over judicial economy, or this judge knows the case already. And they could probably get another judge to come in here and handle this and still try it in August 29th.
Yeah.
It's not even June yet.
Yeah. And Tim, I was going to ask you that, but by the way, it's not just Donna Adelson here who's being, tugged around. It's the Markel family. I mean, Ruth, Bill,
Right,
Shelley.
right.
I mean, what do you think it's like? What's this like for them right now? Because now this is a whole. I mean, this is a literal curveball coming out of left field, and
they probably don't even know about this, the nuances of this motion. They probably don't until this show.
Yeah,
I haven't seen any in a Democrat talking about this, and they cover it daily. This is the first about this motion that's been released.
There you go. Best guests, Tim Jansen. Lindsay Goebel here to Jessica. But wouldn't the wiretap, and this is what I think this is what Josh was asking about before, but wouldn't the wiretap they did on Harvey's phone confirm these allegations if they were tapping? But I don't see the state filing anything that wasn't true. But this would be I'm confused because
you're not going to get me on that.
Jessica, go for it. Just answer.
It's not for me. Oh, they think the state are above board. No, the state are not above board. The state are not above board ever. And I think that what Tim, no offense.
Prosecutor of the year.
No offense, prosecutor of the year, right? But I think what Tim was
Look how
saying,
innocent Josh is. How could you say that?
In terms of the prosecution just should have gone to another judge with this. I mean, I think that that's the most obvious thing. And so the fact that they didn't is not a mistake, right? We're not this is too serious. And this case is too high profile and too public for this to be a mistake. This was a strategy, right? This is the state's strategy, and the state got away with it. And the state got away with it when the judge didn't read it and say, what? I'm recusing myself. How dare you? Right? No matter what the cost.
Yeah, this is fascinating. So, Josh Ritter, to you, hypothetically, if two things, is a judge allowed to say, no way, I'm staying on. This is my case. I'm staying on. At what point is a judge no longer in charge of his own decision as to whether or not he's going to be able to adjudicate a case?
Right now, I mean, he has said that. He said, I'm staying on. They asked him twice, and he said, no, I don't. I mean, that is not a small point too. He could have even said, regardless, he could have said, I do not feel that you have reached the legal threshold for my recusal, but in the abundance of caution, I'm going to have to recuse myself. I mean, a judge can at any point in the pursuit of, the overall good and pursuit of justice decide I'm going to go ahead and recuse myself, just so there's not even the appearance of some sort of impropriety here with me continuing to preside over this case. He did not do that, and he denied both of their requests based upon just the legal merits of them. But now, the appellate court could, there's a chance if this is the first time the appellate court has actually heard of the substance of what was in those affidavits that Judge Everett did learn of, and they do feel like that is problematic enough that he should have told them at that point, you need to go talk to somebody else regarding these warrants, or I'm going to have an actual hearing on this and allow the defense to be heard, and chose not to do that, and that somehow has tainted his ability to preside over this child. They could send it back down and say, we agree with you. You're getting a new judge.
By the way, in 2 weeks' time or less, June 11th and June 13th, there's supposed to be hearings on this case. The first one is listed as case management, and it sounds like they might have a lot of managing the case to discuss. And then on June 13th at 9 a.m., the other one's 2:30, but on the 13th at 9 a.m., there's 2.5 hours set aside for potential venue change. So not only a judge change, but a venue change. So neuropsych Zena here to Tim, as we try to continue to sort this out. if the wiretaps, Tim, had found evidence of this wrongdoing on the part of the attorneys, this is where I think people are conflating two situations. Wouldn't that info have already been made public? They wouldn't have been wiretapping the attorney's phones. They were wiretapping Harvey's phones, right?
That is correct.
Okay.
And because they knew that the attorney was involved, if you remember the last hearing, there was questions about what's called the taint team. They had a separate team that was reviewing the wiretaps to make sure that the prosecution team didn't get any of the attorney-client privilege information. But you're right. If the lawyers did something wrong and the judge got this information and the prosecution knew they did something wrong, they have an obligation in Florida as a Florida bar member. If you know of a member that's violated the Florida bar, you have an ethical obligation to report that to the bar, or you can be disciplined. Now, I'm not saying they did, but we see this affidavit now, and it appears in the affidavit just by the allegation, they're alleging some misconduct on behalf of the lawyers on the phones. They're alleging that in their affidavit to get these wiretap or this tap and pen and trace. So if they had something, you would think, are they not going to file charges because they don't want to continue the trial and disqualify the lawyer? That would be another issue. So we really don't know until I'd love to see this affidavit that's under seal. And I don't know if we'll see it. We only got to see the remnants of it in this motion, only parts of it. I'd like to know what the other allegation. It appears they're claiming, because there's some denial, that they were trying to get witnesses to tamper with witness, to hire witnesses to testify. And this clearly, they deny that. So it's a murky water, no doubt.
By the way, happy upcoming birthday to Rachel D in the chat. She said that she was looking forward to a little birthday gift with the start of Donna's trial. That's not happening. Teresa Nick here. Thank you to everyone. I love this podcast. Thank you very much. Member, look at that. 27 months. If my math is correct, that's more than 2 years. Even Jimmy McNutty is here. Let's see what Jimmy has to say here. I understand the ex-party argument, but what about the content of the warrant request is giving Judge Everett a bias? Jessica, you want to answer that? By the way, before Jessica answers, people don't, they're criticizing Jessica, but you know what? She's a damn good defense attorney, and that's why you're criticizing her. And she stands up for her clients. And in this case, it would be Donna Adelson. That's the job of a criminal. If you get in trouble, and it's not that hard to get in trouble, all you have to do is text on your phone, not pay attention, and run someone over, God forbid. And then you're calling Jessica Mashali, not her that, God forbid, but God forbid you run someone over. We'll do this in a minute, Linda. I don't know. I can't recap. I'll have Tim recap. But anyway, Jessica's job is very important, is what I'm saying. And she's a very vigorous defender of her defendants, her clients. And that's why she's telling you the way she sees it. But go ahead, Jessica. Now I don't even remember the question.
Well, thank you for your kind words. And they love to hate me, right? But haters gonna hate, and I just win, and I mean win, right? So these same people will call me if they're ever in trouble.
Yeah. Exactly.
So I wanted to say something about what Tim said before I answered your question. So he was talking about the situation. And so the last time I was on this show, we were talking about Rashbaum withdrawing, right? Or, and the comments that the judge had made about Rashbaum and his order, and things like that. And so something important to note here is that this would bring up a conflict between Donna and her lawyers. And that's something also that I think the legal minds here are thinking about too, which is that if any of this were true, then these lawyers become her co-defendants in another criminal prosecution. And these are no longer her lawyers, right? And this also would not be the first time that if a lawyer is accused of a crime and doing so with the defendant, and which is their client, the lawyer can flip on their client, right? And they will do so. They'd rather lose their bar card for that than go to jail.
Wow.
As well as the defendant can flip on their lawyer, less common, but also happens. So this is bringing up so many legal issues. And that's why I was saying, and I think Tim agrees with me, that would have been the easier thing for the judge to just recuse himself. It's bringing in so many issues. And when you look at the people who are commenting sort of against me, and I might have like a bad vibe, this is a reality vibe, right? They're doing the defense favors when the state acts like this, right? Because what are they doing? I think the general kind of opinion we've had on this show many times with a lot of attorneys is that Donna Adelson's probably not going to win, right? She's going to be found guilty. And what are they doing? They're setting up all the appeals she needs by having all these different legal issues at play when it really could have just been clean and they could have won anyway. Yeah. Right. So I think that's where we're at.
Yeah. Tim, we got to address this because this is a super chat and I know Marcia. This is back to Wendy for a minute, which maybe we need a slight break from what we've been discussing, but she's been waiting patiently to hear from Tim about his change of heart with Wendy's situation. And if you recall in the last show or two, Tim said that it wasn't him. He said that, I believe, Tim, you said it was the tenor of what you were hearing.
It wasn't me. It was a prosecutor's response that was a little weird under the circumstances, but I haven't heard anything since that time. I think right now this prosecution team has their hands full trying to get this case to trial. And I think Jessica is correct. Sometimes prosecutors overdo things. And when they have a strong case, they overdo it so much that they lose credibility with the jury and sometimes open up things for the defense to jump in on and try to create reasonable doubt when it's not there. So I don't know if that's going to happen here. And I don't know if anybody violated anything, but the motion, they really put the judge in a bad spot. The appellate court, en banc, you get enough of them. Now, this appellate court is very conservative, appointed by the last couple governors that are all Republican. How they respond to this, some of them will even hit the fundamental fairness issue that maybe too much, it's too much. Now we need to, let's get a clean, fresh start. And, the chief judge could also step in if he sees this motion, becomes aware of it. He could go to Judge Everett and say, listen, Judge, what do you think here? Might it be better if we just, let another judge handle this? I don't know if that's true, but there's a couple ways this could shake out.
Stacy's mom in Georgia, we trust. Of course, that is Georgia Cappleman. I agree with Alaska here. This is getting way too complicated. Is Jessica going to play us something on the keyboard? I just read that now. Maybe she'll take us out of the podcast with a little song.
I'll have to bring the kids. They're the ones who will do it. Yeah.
So just to recap a little bit of recent history with this case, on April 7th, so that's going back a month and 3 weeks, these discovery materials, these 100,000 emails were suddenly provided to the defense, and that's when they're like, wait, we need more time. 4 days after that, they filed a motion, the first one, to disqualify Judge Everett. 3 days after that, a trial court denies the motion as legally insufficient. And then it's a second disqualification of the motion filed after more discovery is received. On April 16th, that second motion is also denied. And then on April 23rd, a petition for writ of prohibition filed to remove Judge Everett is, I guess, filed again. And then on May 9th, that petition is denied by a panel of 3 judges. So I don't know if I'm reading this correctly. I believe it's then, Josh, 3 times. And I guess this would make it the 4th or 3rd. I'm not sure, but I think this would make it the 4th time now in basically a little over, 3 or 4 weeks. A little over a month that they're now trying to get Judge Everett off the case. Now, if this fails, if this doesn't happen and he stays on the case, which I have no idea if he is or not at this point, to Jessica's point that everybody's a human being, I mean, how does the judge rule impartially here? Because not only is he going to be annoyed with the defendant, he's going to be annoyed with their attorneys here, right?
Yeah, I think a lot of this can be chalked up to all's fair, love and war type of thinking. I think that the judges are used to, especially defense attorneys, coming after them strong, asking for mistrials, making accusations of misconduct and unfairness, and we're going to writ this and we're going to appeal that, and we're going to challenge you, we're asking you to step down. And I most judges, I should say, and I feel like Judge Everett probably falls into this category. I think he's a pretty good judge. I think he probably is the type with thick enough skin that he could put this behind him and still preside over this and not hold some sort of personal agenda, personal grudge. The problem is the appearance of it. And will others watching this, and especially as Jessica pointed out, when this case, if there's a conviction, likely so, and an appeal, very likely so, will this issue in particular not be viewed the same way by the courts afterwards? And will they find that this was a problematic enough of an event that him continuing to preside over it will create problems? And that to me is probably the most serious thing if you're concerned about this case and justice being done and the justice for the Markell family, is you certainly don't want to be going through all of this again over something like this. And so I think, I don't know if I feel as strongly that it is as a hugely fundamental issue that the judge needs to recuse himself, but I do feel that it would definitely be an issue brought up on appeal. And now you're playing a game of, will another set of judges view this differently than this current set of judges is viewing this what are they calling it? Rehearing on their motion.
Ritter, since Tim did this originally, a lot of people are asking, can you guys give us a 2-minute Cliff's notes? It's Cliff's, I believe, not Cliff's, COE. I'm very particular. Version of the motion for those of us in the back that missed the first half. So she's like steam is coming out of her ears right now. But Josh Ritter, can you just briefly explain what the hell is going on right now?
Yeah. So you're right. So what happened is, for these reasons, and we didn't know any of this until now, they asked for Judge Everett to recuse himself. In Florida, that first goes to that presiding judge. That judge makes a determination just based upon, have they met a legal burden? Have they, in other words, have they provided enough, have they satisfied the elements of recusal? And if they feel that, assuming all the facts to be true, they haven't even legally satisfied that judge can deny it, which Judge Everett did. Then he did it again, and now they then asked for that decision to be reviewed on appeal. That was denied, and now they're asking for a rehearing on that because they're saying that you guys missed the point, essentially, to the court, to the appellate court. The point wasn't so much that judges can't do this. The decision, in kind of the most layman's of terms, the decision according to the Court of Appeal was that judges are allowed to do this, and we're not going to say that judges are not allowed to review warrants even in cases that they're sitting on, and that's what you're asking us to do. In this current motion, they're saying, no, you kind of missed the point. That's not really what we're asking. We agree with you on the law. We're saying you fundamentally missed the problem here. The problem was what this judge heard. And what this judge heard is so problematic that this judge should not be able to preside over this case. And that's the decision we need you to make, court, again. So it's almost where we're at is they're just asking for reconsideration. And it is kind of convoluted, but it's them firing as many shots across the bow as they possibly can. They really want to get rid of this judge.
COE, what does this say? Cliffs with an S.
That's an app. It's CliffNote, which has now turned into an app called CliffNotes. But
Cliffs, it's Cliff's Notes. Anyway,
it's CliffNotes.
It's Cliff's Notes. There's an S. Tim, can you defend me? Can you defend me? No. So Tim Jansen, how much time? I knew she'd get all fired up. While the traditional Cliff Notes, you're learning something else here. Study guides are still available and known as Cliff's Notes. That's it. I've won. Cliff's Notes. They've also been joined by numerous. I don't even know what that means. Numerous online alternatives. I have no idea what any of that means. Tim Jansen, how much time? You said this case could still begin August 19th. So my question is, if Judge Everett is booted off the case, which I think a lot of people really like him, so they don't want to see it happen. But if it happens, how much time does a new judge need? I mean, this is Donna's case, but this has a history going back to 2016 or whatever, when the trial started, or 19.
Judge Everett's a great judge. He's a very fair temperament. He's not one that hold grudges. Like Josh said, judges they expect lawyers to fight. Motions for judgment of acquittal, discovery violations, prosecutor misconduct. They've seen and heard it all. But this case is an oxymoron, right? This judge has been on this case. We've had the whole conflict with Daniel Rashbaum that no one caught for years. Now he's done everything to cover that up, and now we have him looking at some possible misconduct by lawyers, having ex parte communications, giving pen, trace, and trap, and now they're asking that he cannot be fair. At some point, that drip of water, gets to you, and the judge, I don't know, maybe he will say, hey, out of abundance of caution, you want another judge? Fine, I'll recuse myself. But I'm sure they don't want him to. He knows everything. He's got lots of pretrial motions still pending, get the change of venue. He's already ruled on some. So the new judge coming in probably doesn't have to make a lot of rulings. The change of venue it doesn't have standing yet, because in Florida, you have to try to pick a jury. You have to try to pick a jury, and then only if you can't pick a jury, then the trial judge can determine whether a change of venue is proper. They haven't tried to pick a jury yet. So I know they have that hearing coming up, but I think there are other judges who could try this case. And I'm not advocating for Judge Everett to get off, because I love him trying my case. He's as fair as you can get. He's very knowledgeable. So I don't know what's going to happen.
Yeah. And then Jessica, to you, from Michelle here. Tim has practiced. I think Tim has said in his 38 years, there's been one venue change, and there's a motion for a venue change and a hearing coming up. What are the chances, in your opinion, I guess, in light of the complexity, with this added into it? Is there a chance here that they have to move this trial altogether?
Very low. Tim has seen it once. I've seen it never. So it's, it's just right around that year's difference. I've seen it never in real life. I've seen it in the movies. I've seen it on TV. I've seen it never in real life. So it's hard to believe that there would be a venue change. You have a judge who doesn't even want to recuse himself. Never mind, take this into a different venue. I agree from what I've seen, though I've not practiced before him. I think he's an excellent judge. And again, I'll say, I do not think the state is above board. I think this was strategic. I think this was a decision that the state made, but at this point, you can't unring the bell and nothing can be done. So the judge heard what he was going to hear. The judge is thinking this about Donna Adelson and her attorneys. And it's not so much about, with these motions, whether or not this judge can be fair, because how would anybody ever judge that? And whoever is going to come and point at one judge and say, you can't be impartial, but some other judge could. It's about whether Donna Adelson has a reasonable belief that he cannot be fair. And knowing what we know, right, I think it's pretty clear that she does have a reasonable fear that she's not going to receive a fair trial. And Joel, with regard to your question, a judge doesn't need any time at all to get ready for a trial. The judge is not supposed to know about the case before the trial and is not expected to know anything before a trial. The judge is supposed to rule as it comes. and to rule simply based on the law. So they can assign another judge. And I've had it happen to me where actually what happens a lot down here is that we have a case in front of a judge for 5 years. And then on the day of trial, that judge has 3 trials in front of them and sends them out to all random judges. And we go to a judge who's never heard about the case before. And it happens in murder cases. It happens in less serious cases. So there would be no problem for another judge to try this case.
Here's a question that's being asked of Jessica, which I'm going to ask Josh. But first, I have to read something from my friend ChatGPT. Cliff's Notes are named after Clifton Hillegas, the man who created them. In 1958, Cliff began publishing study guides in Nebraska under the name Cliff's Notes, starting with a guide to Hamlet. The idea was inspired by Canadian study guides called Cole's Notes, and Hillegas got permission to create a U.S. version. His concise, accessible summaries of classic literature quickly became a staple for American students. Cliff, it's either Cliffs without an apostrophe or Cliffs with an apostrophe, but either way, it is got an S at the end. So,
I don't know, because I always just read the book, Joel.
And the other thing is, Cliff now, what they don't tell you is he lives in a castle in New Zealand on 25 billion acres because he came up with the idea for Cliff's Notes. So, hold on, COE, that was a question for Ritter. The question, I think, Josh, was what, if any, motivation would the government have here in making these sorts of potential allegations about, wrongdoings?
I mean, it's interesting. Okay. To be clear, this was brought to the judge by the investigators. You have to assume that the investigators ran this by the DAs before they went about doing something like that. So I'm not going to try to say, oh, the prosecutors, this isn't about them, this is about the investigators. So you have to imagine, in a case of this magnitude, they said, we're going to go out and do this. And again, I can't imagine, maybe Jessica would disagree with me, I can't imagine that they would put something flat out false in the affidavit, especially on something of this kind of salacious a magnitude. So I have to imagine there's something that is giving them a basis for making these allegations. But really, the purpose of the warrant wasn't so much to expose that as much as they want to get these, they want to be able to tap Harvey's phone. And so I think what they're most concerned with is what communications is Donna having with Harvey that we're not intercepting, because she's, we believe, doing it in a surreptitious way by going through her attorneys. So we want to end around that and find out what in fact is she communicating to Harvey. And I don't think it's really about Harvey as much as it's about Donna. Is she sharing information, doing things, trying to coordinate witnesses, whatever suspicions they may have in the middle of all of this, and getting that information to Harvey in a way that we can't intercept? That's what they're most concerned with. That was the strategy behind it. But I have to imagine, if I'm being as objective as possible about this whole thing, that they ran this all by the prosecutors before they went out and tried to get these warrants.
I mean, Tim, to you, could you just explain, I guess, from a judge's perspective, is it common for these judges to get like these warrant affidavits after a case is already like pending trial? So like, at what point does Everett have to say, hey, I can't help you with a particular warrant because things are already moving?
Well, sometimes they do. But you would think that it wouldn't happen because something like this happens. They got plenty of judges that they could take it to. But like I said, he's the criminal chief judge. So sometimes administrative, and I know the investigator very well. I've known him. He's above board. He's not one of those that cuts corners and does things nefarious. I think he just took it to the judge because he knows the case. The case has been going on. I don't know. I also can't believe that Josh or Jackie would do something. So, and I don't know if they did, but it's pretty serious if you bring a phone in and then let your client use it, if they did that. I'm certain they're not trying to get tampering witnesses or get false witnesses. That would be foolish. But I think the state, because of the stakes in this, they really wanted to make sure information came to them, probably from a confidential informant, and they wanted to track it down. So they originally get the phone calls, they get the records, then they get records showing these phone calls going at the same time that the lawyer is at the jail and calls going to Harvey. And then they go back and get a trap and trace and a pen register. And lo and behold, we got a lot of overlapping. There's some smoke there. And unless we see the entire affidavit and what the confidential informant said, which we don't know, they just took it to the wrong judge. That's my opinion.
Yeah, I hate to bring this comment up, but since he paid for it in a super chat, He's a Doll says, guys, you're like the hottest men in true crime. Dang, awesome show. Did it? Thank you, He's a Doll. Look at Josh Ritter, the Silver Fox, Tim Jansen. You ever seen a head of hair like Tim Jansen? Jessica, you were shaking your head while Tim was talking. How come?
So I always agree with Tim because I think we're both diehard criminal defense lawyers, and I love that. But I would have to respectfully disagree here. And I think it's too big of an act to just be random or just be coincidence or just kind of have happened. I don't see how the prosecution on a case that is this high profile and has had this many issues and has this much attention makes a decision sort of like willy-nilly or without thinking about it, or, oh, we just brought it to this judge, we didn't really think about it, with this kind of information. This kind of information is extremely prejudicial. You don't bring it to this judge. It is really a no-brainer to look at this information and to say that the judge who's trying this case should not have been privy to this information, in particular where it's ex parte. That is a huge aspect of it, in particular where it's not just emotion, right? The judges expect the lawyers to fight and they expect the lawyers to come in with different motions. And that's a fair fight. And that's what our justice system expects of us, right? But an ex parte communication, for him to find this out where the defense is not present to have a say and where the defense doesn't even know that the state knows this information, right? I think it's the state had to have known what they were doing. And if they had to have known, then you have to think of, well, why did they do it? And what we're seeing right here proves it, right? Because what we're seeing is that while it's highly prejudicial, the judge refused to recuse himself and the Court of Appeals already agreed with him. So they won in their strategy. Their strategy was to prejudice the judge against the attorneys on the other side and against the defendant. And they have succeeded, period.
You know, I think we all agree that we would all be really upset if this happened to us as a defense lawyer on the case. I mean, we would really be upset. I would be going up to Jack Campbell, the elected state attorney. I would be filing motions, and they say, why are they filing motions? You have to file these motions because that's your job as the lawyer. When you have a responsibility, and these are serious allegations, and you're sitting before the same judge. You have to try a murder case, and you got motions that can go either way. Some of these motions are pretty close calls. And if you have been alleged with misconduct or criminal charges and you don't even know it, and the state has tainted your reputation, it's not good.
I like the comment.
So Alice Ryder-Feld is actually an attorney in Miami, Josh. And she says, really, they screwed up the conflict issue, and that was a no-brainer. Talking about, I think the previous defense. So I don't know. Any response to this, Josh? I don't want to put you on the spot here.
Yeah, I mean, this case does seem to be having difficulties launching, right? And it not to catastrophize the whole thing, but I whoever made the point earlier that, once we get past this whole hurdle with the new judge, now are we going to have problems with the defense attorneys having been accused of committing crimes, which may be a bigger problem to the overall delay of this trial, if that's in fact true? I kind of, just to explore that side quest for a moment, I kind of imagine that the defense attorneys would not highlight this as being one of the things that they take most offense by if it were in fact true. So I think that they probably feel very strongly that what is being alleged here, they have either an explanation for, or a defense, or it's just not, it's a confusion on the part of the prosecution, or a fabrication on the part of law enforcement. I can't imagine they would just dime themselves out like that in this motion just simply to try to get the judge recused. But yeah, I mean, it does seem as though this case is more cursed getting to trial than most cases you see.
Yeah, I would say that that's definitely accurate. Look at Copper Horse. Telling people to smash the like button. That's a good idea. Please do that. Subscribe if you haven't subscribed. I mean, to the point about Jack Campbell is the state attorney in Leon County. So, Tim, as far as you know, as far as we know, and just to be clear, this motion that was filed, this has not been ruled on yet, right? So,
No, not yet.
So I guess I have a couple of questions. Number one is, does Jack Campbell get involved at this point?
Well, the state gets the attorney general, who's probably going to represent, and they'll file their response. I always like it when they file motions that include things that are under seal, so we get to see some things that are really out there, so we can glean what's really happening. So I'm curious to see, now that they quoted parts of the affidavit, if the state's going to quote other parts of the affidavit for their viewpoint.
I mean, Tim, are they going to have? I'm sorry, are they going to have a response, like their own motion, responding to this motion? And when do you expect to see that?
Well, they have deadlines and timelines, and the court may give them a timeline. I don't know the appellate. I don't do a lot of appeals. I did that a long time ago. So I don't know if they have 15 or 20 days to respond to this, but they'll certainly get a chance to respond.
By the way, Joel's the guy who comes into study hall the night before finals begging people for a summary of War and Peace. Let me tell you, Donna's banana bread. That is 1,000% wrong. I'm not competitive. I am not defensive. However, I was a studier, and I'll tell you why. My sister was valedictorian of her high school class. And when I was in middle school, she would study from 3 p.m. to like 9 o'clock at night. My sister's, I love her. She's a bit of a robot. And it paid off, because she became a doctor at 22, and I'm a podcast host in my 50s. So that's all you need to know. But the reason I bring this up, while she has a much higher IQ than me, it was the COE who would study very last minute. And by last minute, I mean while taking the exam. COE was not the most studious person in the world, but her IQ got her through. Now, if the COE had applied herself properly, she would have been a Harvard undergrad, a Harvard law school, Harvard whatever, and she'd be commenting on this case. But
now, see, those are called ex parte accusations that you're making there, because she's not here to defend herself.
She's gonna hop back.
She can pop in whenever she wants.
Imagine the hate I'm gonna get for these comments. No, the COE is honestly very, very. As is Space Coast, by the way, her brother on the West Coast, very high IQs. And the other two siblings are pretty hard workers. But so are these.
Hard work.
Anyway, I'll
Joel,
move on.
or you get in trouble.
Yeah, I'm switching gears right about
Insulting
now.
everyone.
Tim Jansen, I have to come back to you on this, because now people are asking, and you're the new Wendy expert. So what does this do to any? What does this do, if anything? I mean, let's say that they were planning, hypothetically planning an arrest of Wendy Adelson. Now what? Because some people think that this is deliberately being done to maybe save Wendy, which I don't. I think that's absurd. I don't think that's happening.
They have to. The only patient on the table right now is Donna. The doctors and prosecutors are focusing on Donna. I haven't heard of anything that leads me to believe that Wendy is going to be charged prior to this case being resolved. So all the Donna people, just wait in line.
Wendy people,
just wait in line.
Jessica, to you, and then we'll start to get some final thoughts here. This motion, do you believe it's, I guess, more persuasive? I mean, I think I know your answer, on a legal basis, or is this kind of tugging at the emotional courtroom of public opinion strings?
I think it's very persuasive on a legal basis. Now, that being said, these are.
I only asked that question so you would get more hate than me for. I said my wife is very smart. I just said she's not the most studious person. Go ahead. I'm sorry.
These are very hard to get granted. You know, I've filed a bunch of motions to recuse in my time. It's not common for them to get granted. This has already gone to the Court of Appeals. They've already denied the writ, right? And now we're asking for a rehearing. Rehearings are very hard to get granted. Rehearings are basically you're asking for the same thing and pointing out respectfully that you believe the court made a mistake. How often does the court say, oh yeah, I made a mistake. Here you go. We're changing our mind. But I think that, you know, one important distinction is that there's some new information here, right? That we haven't seen before that is under seal. And I think legally, it's very persuasive. Listen, I don't want to argue on behalf of Donna Adelson, right? I'm happy I'm not her lawyer, but I have to call it as I see it. And the way that I see it, what happened should not have happened. And there is certainly a reasonable fear from Donna Adelson that she will not get a fair trial from this judge. It's not because the judge is not capable of giving her a fair trial, but she has that reasonable fear and she should get a new judge. I think the motion is very persuasive.
There you go. Don Moore. Josh, for you, is this going straight to the appeals court, or is Everett, does he hear this now first?
No, he's not involved. They're above his head at this point. Yeah.
Okay, and then another one for you, Josh, since you answered that one so succinctly. I'm afraid that Georgia Cappleman, the prosecutor, let this get away from her. Josh, as I don't know if you know, he's former LA Prosecutor of the Year, Josh Ritter. I mean, can you blame her for this? Can you point the finger at the prosecutor on this one?
Well, again, I cannot imagine that in a case of this magnitude that the investigators are kind of rogue, going for warrants without running it by the prosecutors when they're heading into trial. So I imagine that this was ran by the prosecutors beforehand. But it is interesting that, you know, they intend to prove their case, and they intended to prove that before whatever information they were seeking out of these new warrants, right? And so it does seem very aggressive to be taking this perhaps, you know, risky chance of trying to get these warrants just so that you can perhaps learn new information about your current defendant. Maybe that's a confusing way of saying they announced ready. They're ready to go. They were ready for trial months ago. We thought we were going to begin trial, and now we're still seeking and getting new information and trying to investigate and trying to see what communications are taking place. That's one, very aggressive, and you can appreciate that. But two, there's a risk involved in all of it, and now you're seeing what could be the ill effects of that risk is that you might be losing your judge.
This is a fascinating twist and turn of events here as we, on the last show, I think we were talking about the continuance to August. Now, who knows what's going to happen? If you don't know, now you know. He is former LA Prosecutor of the Year, criminal defense attorney, but he is host of so much more. Courtroom Confidential. It is one of the most happening true crime podcasts that there is on the YouTube and everywhere you find podcasts. So, Josh Ritter, what now? That's my question.
If you're asking me to bet on whether or not this is successful, I think it was Jessica put it best. You know, you're asking judges to second guess themselves, and you're asking, even if you're asking for an en banc review, it's still judges that sit, you know, next to other judges, have offices, chambers two doors down from other judges, and having them second guess a decision that they made. The one thing that is interesting is you could even maybe view this as an attempt to kind of dime out the judges on the first appeal by saying, hey, you guys missed it so bad. We're going to now publish, in fact, what the shenanigans taking place were, so everyone can see it, why we're so upset about this. And we're asking for reconsideration just so we can put it out there in front of everyone, what it was that was taking place, why we're asking for this judge to be recused. And maybe there's this outside chance that they're feeling that the judges will, I don't know, be bothered by that's now public out there, what in fact was in that affidavit, enough to say we are going to reconsider. Maybe it's my cynicism. I don't think it's going to be successful. I think that the judges are going to say, no, they base their rulings upon the law. The law says there's nothing wrong with this. What was put into this new motion doesn't give us anything why we even need to reconsider it. I don't even think it will go as far as having a hearing or review on all of it. They could just say, we're denying your request to revisit this. We're denying your request for a rehearing. There's nothing you presented that changes that feels like we should even entertain a request for a review on it. And I think we'll proceed forward. That's just my take, my gut reaction to how these things usually go.
Well, that's a positive note. So maybe August 19th, it will happen. Back pain forever. Defense attorneys always think their motions will get granted. I'll let Jessica weigh in. But first, Jessica Mishali, she is a criminal defense attorney from Boca Raton, Florida, originally from Miami, and an all-around very formidable and tough defense attorney that you do want on your side. Trust me. There's a question here, Jessica, before your final thoughts. What should have been done from Flora Paris? What should have been done with information about possible defense misconduct? I mean, we talked about this a little bit, but to flesh it out, what should have been done or what could be done?
I think if they wanted to get a warrant using that information, they should have simply gone to a different judge. I think it would have been just that simple to keep this judge on board. And that's all it would have taken. So that's what I think that they should have done.
Yeah. So same question I asked Josh. What now? What do you think happened? Do you agree with Josh that this is just going to move forward and they're basically going to deny whatever they're asking for here?
I do. I do agree with him that that's what's going to happen. Though I think the motion
why?
Why agree with Josh?
No, not why I agree with Josh, but why do you think that? I mean, I'm curious.
So unfortunately, we see this get played a lot of times. Like I said before, when you lose, you always file for a rehearing. The rehearing 9.9 times out of 10 is denied. They're asking for a rehearing, and it's even more difficult because they're already at the Court of Appeals level. And statistically, your chances go down, down, down. Your best chance of a win is at the trial level, right? And then it goes even less. So people who wait to hire their lawyers for appeals are not doing the smart thing. It's statistically less of a chance. So you have this coming before them again and again. And in order for them to rule en banc in favor of the defendant, they will have to say they screwed up. Right. And how likely is that? It's very, very unlikely. Is it possible? Yes. Do I think the motion's persuasive? I think it's very persuasive. And I wouldn't be shocked if the judge makes a decision to recuse himself, especially now that this is out there at some point. But do I think that the Court of Appeals is going to make that ruling? I don't. I disagree with them. I think that this judge should not be on the case going forward. I agree, though, that Donna Adelson should be brought to trial and that the trial should move forward. I don't think she should be given additional time. She's not losing her lawyer at this point. But it's definitely a very shaky situation here with these lawyers as well, being accused of not only crimes, but crimes that they're committing together with the defendant on the case.
Yeah. And by the way, got to note that, and Tim knows this a lot better than myself, but when Jackie Fulford was a judge, she basically was forced into resigning. Correct, Tim?
That is correct. She took a disability. She was under charges by the JQC, but then voluntarily resigned with a disability.
Yeah, and I think normally that wouldn't be that important piece of information, but with some of the allegations floating around, maybe it is. Tim Jansen is the GOAT on this case. He is the famed Tallahassee criminal defense attorney, the letter R, Timothy Jansen, and OUR. And I learn a lot from Tim all the time. Julia Nielsen here with a very simple question. Are they stalling? I mean, if I'm Donna and I'm complaining the way she's complained about jail, including her narrow ear canals not being able to be flushed out properly, I want to get out of there. I want to go to trial. So, Tim, are they stalling? And what do you think happens next?
Well, one, I think giving them 100,000 emails right near trial was perfectly reason for a continuance. That should have never happened. And the state said they didn't get them, whatever. This came to their attention. They were filing another motion. And when this came to their attention, they immediately filed a motion. I agree they should have filed it. I understand now, looking at this affidavit, what they've included, why they want to go in bonk. But, getting in bonk means you, like you said, all the other judges that you have lunch with all the time, you're going to say these three judges did the wrong thing. The judge that wrote this opinion, Judge Long, was on this circuit, so knows Judge Everett. Okay. So if you ask me what's going to happen, do you remember the movie A Few Good Men? Mm-hmm. Remember they said, I object, sustain. I vehemently object, Debbie Moore said. Oh, you vehemently object, sustained or overruled. So that's what this is going to be. It looks good on paper. It gives you a good podcast, but in reality, 99.9%, they probably won't even be a per curiam, and they won't even require the state to respond.
I love when lawyers just drop, like, I've never heard the word per curiam in my life until right now. I love when judges drop this stuff. But Tim, when do we get an answer? You said they the answer is going to probably be move on, but how do we know? When will we know?
We'll probably know something if they require the state to respond, or if they file a response, probably 10 days. We'll see.
Oh, great. That'll be right. And are those hearings, do you think, are they going to happen as scheduled? The case management and the change of venue, that'll happen?
Yeah, they still have jurisdiction. They're just doing this to try to recuse the judge, and the judge will proceed until he's told by the appellate court or the chief judge, you're no longer the judge. Mm. And if they kick him off, then another judge will step in and walk in because he wears the same kind of black robe. He sits in the same chair, and then he'll make the ruling. So judges are interchangeable, just like state attorneys are. So
there you go. What a day. What a story. I'm thinking of a weird story from my past just to prove that I was studious and I was in the library. I don't know about today's technology, but when I was at Brandeis University before Wendy Adelson, when you go into the library, do you guys have this thing where it's like a turnstile, but if you have like a barcode in your book, it would freeze the turnstile. In other words, you're trying to steal a book from the library. You couldn't get out. So
how many times did that happen to you, Joel?
Well, my rotten friends, I'll tell you what my friends would do. I spend a lot of time in the library, and they would find the smallest books on the most disgusting things, and they would sneak them into my bag. And then I would get stopped by the librarian, and they pull out like a 3x4-inch book about like, how do you cure your STDs at home or something, And then the librarian would be like, oh, did you check this out? And I would have to say, no, those were my idiot friends. And they'd be in the corner hysterically laughing. So, ladies and gentlemen, that's how we used to have fun before Instagram and X and those things. That's how we used to do it. Anyway, on that note, love you, America. Justice for the Markells, first and foremost. Donna, I'm sure you want to get out of jail. Huge thanks to Josh, Jessica, Tim. This was a great panel. Appreciate you all. And tomorrow I'll be giving you a Diddy update at some point. And Phil and Scott are coming back. They are back. We'll see you tomorrow. Guys, stick around 1 second.